Let's talk about solutions around inadmissibility to Canada. But before I continue, please subscribe to our channel and enable notifications. Inadmissibility to Canada affects foreign nationals and permanent residents of Canada. If you are inadmissible to Canada, then you cannot travel to Canada, you cannot immigrate to Canada, you cannot apply for a work permit or a study permit to Canada. If you're already inside Canada, then the immigration authorities may move forward to remove you from Canada and issue exclusion orders, departure orders, or deportation orders. In this video, I will briefly explain what are the causes of inadmissibility to Canada, but my main focus is how to resolve those issues. I have another video that I have explained inadmissibility to Canada in details. You can check out the link up here. If somebody is inadmissible to Canada, the cause could be security reasons, human rights violations, criminality, serious criminality, organized criminality, medical issues, financial issues, family members, or non-compliance with the act. Any of those causes could prevent a person to immigrate to Canada or stay in Canada. All those areas of inadmissibility affect foreign nationals. Foreign national means somebody who is not a Canadian citizen or permanent resident of Canada, including people who file for refugee in Canada, people who are here as a stateless people, includes foreign workers, international students, or visitors, business visitors or tourists, etc., etc. In terms of permanent residents of Canada, certain areas of inadmissibility do not affect permanent residents of Canada. As I mentioned, I have another video. You can check out which one of them affect permanent residents. I also have an article. I will post the link down below. You can read that article. I have a table in there that clearly says who is affected by which area of inadmissibility. When it comes to Canadian citizens, inadmissibility does not affect Canadian citizens at all because Canadian citizens are protected under the Constitution Act from inadmissibility. However, as a Canadian citizen, if you commit an offense, obviously you need to pay the price, stay in jail, depending on the situation and the decision by the courts. Best way to deal with inadmissibility is prevention. In other words, if you are dealing with a case of inadmissibility, try to resolve it first before submitting an application for immigration, if this is a possibility. For example, if somebody is suffering from a serious disease, maybe it's better to go through the treatment first, so receive surgery, medication, whatever is necessary to subside that medical issue and then apply for immigration to Canada. However, this is not always the luxury that you have to deal with underlying issues of inadmissibility. That's why this video comes into play. There's also always a temporary solution for inadmissibility. It's called temporary resident permit. It's a permit that allows you to enter Canada on a temporary basis. And in certain situations, you may eventually make your status permanent. I have another video about temporary resident permit. I posted up here. During this video, I will also talk about humanitarian and compassionate considerations. This means application for permanent residency, but you do not meet the residency requirements. For example, you are inadmissible to Canada. In those circumstances, you could apply for permanent residency of Canada under humanitarian and compassionate considerations. If the officer agrees with you, then despite inadmissibility, you may immigrate to Canada. However, HNC is not an option for inadmissibility under security, human rights violations, or under organized criminality. I have another video about HNC or humanitarian and compassionate considerations. Please check it out up here. If your inadmissibility occurs inside Canada, the first step for the immigration authorities is to issue you a removal order. They normally send you to a division of Immigration Refugee Board of Canada called Immigration Division. That Immigration Division reviews the case, and if they believe you are inadmissible to Canada, then they will issue the inadmissibility and also the removal order from Canada. That's your moment to fight back. So if you believe that you are not inadmissible to Canada, then when you go to the Immigration Division, you need to present enough documentation and defend yourself. In certain circumstances, if they find you inadmissible, you may even file for appeal to Immigration Appeal Division, or if you are not qualified for an appeal, you may file for judicial review, and through that process, try to fight back and cancel inadmissibility and cancel removal order from Canada. If your inadmissibility is because of residency obligations as a permanent resident of Canada and you haven't met the residency obligations, it is not customary for the immigration authorities to send you to the Immigration Division. They can immediately issue you a removal order. In those situations, you can file for an appeal to the Immigration Appeal Division, and later, if you fail that process, file for judicial review. These are your options when you are inside Canada. If you are inside Canada and they find you inadmissible to Canada and they remove you from Canada, you receive a removal order, and depending on the nature of the removal order, if you want to come back to Canada, then you have no choice but to apply for an authorization to return to Canada, which is something on top of addressing inadmissibility issues. It kind of occurs concurrently, but anyways, you need to know that your problem will not just be inadmissibility, but also not being able to come back to Canada. I have another video that I will post it up here. It's about authorization to return to Canada. I explain removal orders over there and explain how you can apply for authorization to return to Canada. Now that we know the basics of solutions, let's focus on different aspects of inadmissibility to Canada. If inadmissibility to Canada is because of criminal reasons, criminality or serious criminality, it depends on whether your conviction is inside Canada or the conviction is outside Canada. If the conviction is inside Canada, then your choice to remove inadmissibility is to file for record suspension or a pardon inside Canada, or if there are premises for acquittal, try to receive acquittal from those offenses. In that situation, you normally need to hire a lawyer, and that lawyer will help you with the process of record suspension. I have an article about record suspension. I will post the link down below. You can read that article. It gives you more information. If the offense occurred outside Canada, then your chance to come back to Canada permanently, not being inadmissible because of criminality, is rehabilitation. Sometimes rehabilitation occurs automatically and naturally because you committed that offense long time ago. Then it is called deemed rehabilitation. I have an article about deemed rehabilitation. I post the link down below. Sometimes you need to apply for rehabilitation. It is called an application for rehabilitation. If they approve your rehabilitation, they say that you are rehabilitated, then you may travel back to Canada. Obviously, if you have offenses both outside Canada and inside Canada, then you need to both consider record suspension and rehabilitation. If the offense occurs at a port of entry, then in certain situations, if you sign a withdrawal and the officer removes you from Canada and they do not pursue inadmissibility because of those criminal activities, then in those situations, normally you are not inadmissible if you leave Canada with that withdrawal letter, with voluntary withdrawal letter. However, consult with a professional to make sure that this is the case because situation could be different for you. If you cannot address criminal inadmissibility right now, but you still want to immigrate to Canada, then you may file for humanitarian and compassionate considerations. And also, temporary resident permit could be another option for temporary resolving your inadmissibility due to criminality. And as I mentioned, if you have already received a removal order, you also need to apply for an authorization to return to Canada or ARC. Sometimes inadmissibility is because of health grounds. As I mentioned earlier, in certain situations, health ground inadmissibility is called excessive demand. It means that you have a medical condition that causes a lot of financial pressure on universal healthcare system in Canada, or causes significant delays in offering healthcare services to Canadians and increases the rate of morbidity or mortality of Canadians. In those situations, sometimes you can fight back by presenting enough documentation that part of the expenses will be covered by you and not being even inadmissible to Canada. However, if they issue inadmissibility, or if inadmissibility is because of the health of Canadians or safety of Canadians, then in those situations, your only bet is either humanitarian and compassionate considerations for immigration or TRP for temporary status in Canada. For inadmissibility, for financial reasons, your best bet is to resolve that financial reason before applying to immigration to Canada, presenting enough documentations to the immigration authorities that your intention is that when you immigrate to Canada, you really want to be on your own, you won't be dependent on social services and social assistance from the government of Canada. That's your best bet. However, maybe you could include humanitarian and compassionate reasons while you're filing your application. Or in certain circumstances, you may even apply for a TRP. If the inadmissibility is because of security reasons, organized criminality, and also because of human rights violations, then rehabilitation is not an option. Humanitarian and compassionate consideration is not an option. Your option is try to fight back and prove to the government that you are not inadmissible in the first place. So you need to go through several processes which end up in judicial review applications. If you exhaust all those avenues and still they consider you inadmissible to Canada, then you may apply for ministerial relief. I have an article about ministerial relief. I post the link down below. You can read that article, and through that article, you will learn how you can potentially apply for ministerial relief. And if you receive ministerial relief, you become a protected person. You can come to Canada and in many cases eventually become a permanent resident of Canada. Sometimes your inadmissibility is because of a family member. First of all, try to resolve the issues for the family member with the options that I explained before. But obviously, if you do not have solutions for those situations, then you may apply for humanitarian and compassionate considerations, or you may apply for TRP. I have a video about being affected by family members when you are immigrating to Canada. You can also check out that video. If I have room to post it, I will post it up here. Non-compliance with the act sometimes happens. For example, if somebody is inside Canada, they do not hold proper permits, but they are working in Canada without permit, or studying in Canada without permit, or they are overstaying in Canada. Usually those kinds of situations results in removal from Canada, receiving an exclusion order, and you actually can wait for 1 year and then apply for immigration to Canada. However, those circumstances, depending on the situation, like residency obligations, etc., they normally create temporary inadmissibility. The inadmissibility goes away when you leave Canada. And you can apply for immigration to Canada afterwards. sometimes immediately, sometimes after 1 year, sometimes after 5 years. And talking about 5 years, if inadmissibility is because of misrepresentation, then you will be inadmissible for a period of 5 years. If you are inside Canada, you will receive an exclusion order that is valid for 5 years. If you're outside Canada, you're just become inadmissible for 5 years. Regardless, if you wait 5 years, then you can apply for immigration or visa to Canada. However, if you want to come back to Canada sooner, then you need to go through the process of temporary resident permit or try to go through the process of judicial review and remove the misrepresentation if that is an option. Again, I have another video, an article about solutions to misrepresentation. I will post the link down below. Inadmissibility to Canada is a complex subject. I tried to simplify it as much as possible. As I mentioned, I have an article about this that I will publish the post below here. You can read that article as well. But it's very likely that if you are dealing with inadmissibility issues, your best bet is to consult with an immigration consultant like me or an immigration lawyer who has experience with different kinds of inadmissibility issues. Thank you very much for watching this video. My name is Parsai. I'm a regulated Canadian immigration consultant with almost 10 years of experience. Yes, I have dealt with many inadmissibility cases. I'm the author of 88 tips on immigration to Canada. You can find out about your purchasing options by visiting 88tips.ca. Please like this video, share it with your friends, subscribe to our channel, and enable notifications. See you soon.